Hello and welcome to this bite-sized revision video on the principles 2 to 6 of the GDPR, including breach notification. In the previous revision video we explored principle 1, so let's now start with principle 2, purpose limitation. This states that where you have collected and are using personal data for one purpose, you cannot automatically use it for another purpose that may not be compatible with that primary purpose. For example, just because a builder has your details to build your extension doesn't mean he can pass it on to his friend that does interior design because he thinks it could do you a good deal. The interior design of that extension and the building the extension itself are not the same thing, although they might be related. Principle 3 states that personal data should be limited to what is necessary to achieve your purpose. Therefore, you need to determine what you actually need to do X or Y or Z, and do not collect any more than that. Principle 4 states that information you collect should be accurate and, where necessary, kept up to date. Therefore, you need to determine how you will ensure the details for example, Mrs. Jones at number 71 Duke Street, remains that way and doesn't get corrupted, edited in error, or posted in error to the wrong person. How does she remain Mrs. Jones, number 71 Duke Street, as she should do? One of the biggest causes of data breaches is where addresses and email addresses are recorded or entered incorrectly, resulting in information going to the wrong place, either through human error, as seen in this particular data breach, or through poor system design where the system sends something to the wrong place or updates the wrong account. Principle number 5 outlines that personal data should only be kept for as long as necessary. Data protection law in of itself doesn't set any retention periods, but however refers you to legislation that covers your purpose. So for example, banking law will cover banking purposes, social care law, social care purposes, and so on and so forth. Therefore, you need to determine what the maximum or minimum retentions for your records are and ensure you have processes in place to implement and manage them, otherwise known as the records retention principle. Principle 6 is otherwise known as the security principle. This outlines that personal data must be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, damage, using appropriate technical or organizational measures. Examples of what could be appropriate measures include things like encryption, business continuity, risk management, policies and standards, training and awareness for staff, etc., and making sure that you regularly test and monitor your security controls. If the personal data you hold is compromised, it may constitute what's known as a personal data breach, and therefore maybe be something you are required under the GDPR to report to the Information Commissioner's Office. The GDPR defines a personal data breach as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to, personal data transmitted, stored, or otherwise processed. If you believe that you do have a reportable breach, Article 33 then outlines what you must do in order to report it. This includes reporting said breach within 72 hours of becoming aware of it, or explaining why you didn't report it if there was a delay in the last 72 hours. You only need to report breaches to the ICO if there is a higher risk to the data subject's concerns and their rights and freedoms. Things you need to consider when reporting to the ICO include things like the type of breach, its severity, sensitivity, the type of data involved, the number of those involved and affected, etc. In your report to the ICO, it should detail details about the breach. This includes what has happened, what you've done about it so far, and what you're planning to do about it, who the main contact is, and what you envisage the impact of the data subject is. There is no time limit for informing data subjects about a breach themselves. Instead, you need to look at the nature of the breach and determine if it's appropriate to inform them in the appropriate time frame for doing so. The risk exists that when a breach may lead to physical, material or non-material damage to the individuals whose data has been breached, you will need to inform them sooner rather than later. Examples of such damage include discrimination, identity theft, fraud, financial loss and damage to reputation, and those sorts of things. When the breach involves personal data that reveals race or ethnic origin, political opinion, religion, philosophical beliefs, trade union membership or genetic data, data concerning health or data concerning sex life or criminal convictions or offences, or other related security measures, such damage should be considered as likely to occur, as these are special category data and often more sensitive.